G'day, Moon. How are you?
Good, thank you.
Now, Nina and I'm afraid Kim couldn't be here today, so I got another member of our employment law team to come and work with us. How are you?
Hi, good, thank you.
What did you do today?
Um, I got school and I went into an excursion.
And you saw Mars?
Jupiter, Venus.
Amazing. And I sat through a mediation course. Who was the lucky one? Look, today's all about restraints, but we'll come to that a little bit later. I thought we might just go to our first case about Neil Woods. Now, you probably don't know anything about Neil Woods, do you? But Neil Woods was employed by MSS Security, and he worked for a security company inside a hospital. And when he was at the hospital, there was a patient who was disturbed who tried to touch his name badge, made a fist at him, and said abusive things. Mr. Wood's evidence was that he turned him round, took him to the ground safely. But the security business terminated his employment after investigation because they said Mr. Woods hit him as he was putting him on the ground. Now, the evidence was not that. He had a security cam on his vest, which showed him helping the person down, and with his hand around his head, which could look like he'd hit him. The company relied on a whole lot of nurses who said no, he hit him, but they were never called in evidence. So when it got to court, what do you think the court did? Did they think the dismissal was a fair one or not a fair one?
Not a fair one.
You're right, not fair. You're right. And the reason is there's a test called Brigginshaw, which says it's on the balance of probabilities, but where you allege something seriously, you must have real evidence. The failure to call nurses, of course, was fatal because they're the evidence that covered the part of what had happened before. Not only that, the security business actually alleged that he was angry beforehand, something never put in the investigation. So this is another case that we talk about investigations and about the importance of Brigginshaw's case, but there simply wasn't enough evidence for valid dismissal. So, honey, you got it right. Do you want to go to the next case and see how you go that time? So you're 1 out of 1 at the moment, okay? So our next case is an interesting case, okay? This is a case of public service. It's about a police officer. Now, in this case, there was a policeman who was a union delegate, okay? And what he did is shared information with his union, and some of that information related to information which he had no proper right to share with anyone externally. That was the argument of the police. His employment was terminated, okay? And so he went once in front of a court, and the court said, well, your argument that sharing between a delegate and a lawyer is subject to legal professional privilege is not a really strong argument, because that was the argument they defended. They said, well, if I'm engaging a lawyer, it's subject to privilege. You can't look or criticise what they're doing. But of course, the police owned the internet supply that they were using and the equipment. So by its very nature, it could have legal professional privilege, but the judge at first instance found that it wasn't a confidential document for the purpose of sharing. He had no entitlement to share it, and therefore it was a proper basis for termination. And on appeal, the court said, yeah, if you own the system, you're effectively waiving legal professional privilege except in very special cases. Why is this case important? I guess when you look at it, you must understand when you're using equipment of an employer and the employer says it's their equipment and says they have a right to access it and to look what's on it, it's very hard to get around it. So in this case, do you think the police officer won and was reinstated in police, or he lost? What do you think?
I'm pretty sure he lost.
He did lose. That's 2 out of 2. I tell you what, Kim and Nina, you're in trouble. She's killing it, absolutely killing it. Why don't we head off to our next case, okay, which is Martin and Telstra. Now, this is an interesting case, honey, all right?
Mhm.
So Martin was a person who worked in a call centre for about 32 years. The last 2 years, performance had not been great, and there'd been a performance plan that had been ongoing. Telstra were very concerned that this person had a hearing problem, okay? Are you with me up to that? And they said, look, we're going to test you again, but we're concerned that your hearing problem means you can't act in a call centre returning people's calls. There's an obvious problem with that, isn't it? Because earlier tests said she had a hearing problem, and she continued to work for a long period of time. So that's a bit of a problem, isn't it? So this is a breach of contract case, so it's a bit complex. So this is Martin saying, you've repudiated my contract, I want to be paid. Now, when the court looked at it, they said this: one, hard for you to rely on hearing loss, but then you actually directed her to go home on sick leave while you determine whether she's fit for the inherent requirements of the job. Now, you can imagine if I send you home on sick leave, it's your position to take sick leave if you're sick. I can't force you to take sick leave. And when a sick leave ran out, because it went on for 6 months, she wasn't getting any pay. So the court were left with the question: was it lawful and reasonable to direct her to stay at home on sick leave while they investigated? Do you think it was lawful or not lawful?
What's a lawful and not?
Good question. So the test of whether something is a basis for forcing someone to do it is whether, as a matter of law, you can direct someone to work with no pay. No, you can't. 3 out of 3. Okay. And so the claim was upheld. Martin won, and won for a number of reasons, but the obvious ones was it was a repudiation to send the person home on sick leave. It wasn't a lawful and reasonable direction. And to be perfectly honest, in relation to safety law, the proper question is, if you're worried a person can't do the job safely, you must place them on paid leave while you investigate. But the difficulty is here, there'd already been condemnation of the fact the person could do their job because they'd been doing it for a long time. Martin's an interesting case, isn't it? Why don't we switch over to our next case?
Yeah.
All right, now JBS doesn't sound like an interesting case. Now, we do a lot of work in the
I still like it.
You still like it? Well, look, you're 3 out of 3. Let's see how you go this time, all right?
Yeah.
So in JBS, SafeWork brought a prosecution against JBS. So this is the safety regulator brought a prosecution against JBS because a JBS employee who was testing 700 kilogram bale of hay for moisture to make sure it was safe to use didn't understand that if the bale fell, they could actually get squashed and injured. And they did get squashed and injured. Okay, awful. What JBS said is, well, look, we have a buddy system. So I come to work at JBS and you're my buddy and you show me how to do things safely. Okay. They said, look, we did tell you how to actually moisture test the bales. So the person knew how to do it. So we can't be liable. Now, when the court looked at this, it said, but did you ever teach them what would happen if the bales fell and how you could avoid getting hurt? Now, the evidence was they didn't teach that. So do you think the prosecution was successful against them?
Yeah.
Yeah, you got that one wrong. They're bad luck. 3 out of 4. So yes, I guess what's interesting about this case is that a lot of people don't understand how safety law works. This was a high order risk, okay? That is, if the bale fell at 700 kilograms onto somebody, it was going to damage them. So JBS had to be satisfied that a person who was handling or in the vicinity of bales understood that risk and could institute a control to prevent it. And they didn't have that evidence. And in the meat industry, the buddy system is the most common way of teaching people how to do things safely. But the problem with the buddy system is if your buddy doesn't do it safely, you're not going to do it safely. So this is a really fascinating case, and it's a really important meat industry case to show. And high order risk, everyone must have knowledge of what that risk is, and they must know what the controls are. In this case, they didn't. Okay, why don't we go on to our next case and see what we've got here? Okay, this was a funny case, all right? This is in the Northern Territory, and this was a construction business that got into trouble with the regulator because it had problems around electrical safety. And the regulator issued a compliance notice and said, okay, prove to us that you're being compliant. Prove to us you fixed the electrical problem, okay? So they did. They took photos of fixing the electrical problem, but the photos showed that they had people working on the roof that weren't safe or secured. And not only that, there was numerous public complaints about how dangerous they were in construction. And so they were charged with a number of serious charges, including recklessness about their unsafe method of working with heights, which were photographs they gave themselves. So you've got the evidence that there was numerous photographs and public complaints. Okay, they were charged with recklessness, and eventually, to do a deal, there was a plea entered for a lesser charge. Okay, so you don't have to make a decision because it's a complex case. But it's fascinating, isn't it? Because imagine sending photos to your school of not doing homework. You get into trouble, wouldn't you? Yeah. Teacher would say, but Moon, you just sent me photos, a video of you having fun at home, sitting in the cinema watching movies when you're meant to be doing homework. Well, that's exactly what happened in this case. These people knew so little about the safety that was relevant to the nature of the work they did, they actually sent in photos that demonstrated their guilt and which aligned with public concerns. Funny case, there's not a lot that runs with it, but what I do want to show you is that the high order risks continue to come through, don't they? In every case where you don't know a risk is working at heights and you don't protect people, you're going to be prosecuted. What have we got up next? Do you know?
No idea.
Yeah, you got no idea? Well, we're going to go to the main topic. Yeah, this is a Scala's case. So this was a group of employees who were also shareholders. So they entered into a number of agreements: purchase of share agreement, shareholder agreement, employment contracts. And there was a detailed restraint that had in one of them a 5-year restraint, which was a shareholders agreement. And by the way, there's an interesting thing that commercial agreements that are for consideration, so that's like buying shares or doing things or buying a business, the restraints are inclined to have a longer and broader scope of enforcement than an employment contract. So I want you to remember that. The restraint was incredibly broad in the way it acted. It acted for all clients of a Scala, although these people only provided a small amount of very successful people who did one particular thing, but a Scala had a broad range of work. It acted for all clients, people they had no control over, and it had no geographical limit. Now, I'm not going to go into a lot of detail, but this is a great case to read because it brings home to you the primary rules, which are courts are most reluctant to enforce restraints. That's to stop you competing or to stop you having clients. Does that make sense? So when you leave here and you're my employee and I've got a restraint against you, you're not allowed to use my clients, okay? You've got to go and find your own. But because the courts are reluctant to do it, they look very carefully at the words. Now, clearly, anything that has a restraint that's not individualised to the personal circumstance of a person is not going to be enforced. And that's what I want to talk to you about today. When you're using restraints, if it's Moon you're restraining, it's got to be about the job Moon does and what control of goodwill she has. If it's broader than that, it will not be enforceable. And although severability as a concept will apply, and there was a severance clause and there was some cascading clause, the court said in any particular clause, if there's words which taken or removed would make the clause meaningless, you can't sever it. They can't add words. Now that's slightly different in New South Wales, where the courts can read down and recraft restraints. I want you to understand that, okay? Slightly different. But the point of this case is, unless you individualise restraints to what a person does, what the clients are they relate to, the territory in which they work, and a time that is reasonable in the circumstance, simply won't be enforceable. So I think a really important case, and a case that we should think about very seriously when we get involved in it. So what we're going to do today is we're now going to go past this main topic and we're going to look at a case. All right. So this is a case study, and just before I start it, one of the interesting things about a Scala's case is that they executed employment contracts for a period of time which would commence in the future. So they entered it well before they started, and that gap between when they executed it, they had an opportunity to resign beforehand. So the actual employment contracts were held to be not enforceable. So it was a question around the shareholder deed and the share purchase agreement and the restraints that went in there. I raise that now because it's relevant to this case. Now, I've got a bit of a sore throat, so I'm going to have a drink. You can have a drink too. Normally, you'd have to read this, but I think that's a bit tough for you today. So I'll read it. Ivan was a mortgage broker for Home Happy Mortgage Brokers. When he started his employment with HHMB, his clients followed. His clientele came from across Greater Melbourne. HHMB appointed him head of broking for Victoria. He had 7 brokers under him, and enjoyed a privileged position of influence with the National Australia Bank and the CBA. Ivan signed an employment contract with HHMMD. It was finally executed 2 days after he commenced employment. At the same time, he executed a deed poll, or a deed, which had the restraints we're going to talk about. The deed was incorporated by reference into the contract. Now, when you incorporate by reference, what you say in a contract is, this contract is the entire agreement, save and except for a deed which deals with restraints, which is attached to Schedule 1 and is incorporated into this agreement. So it actually sticks them together, okay? The deed came as a surprise to him. The negotiations prior to signing the contract were limited to an agreed position description, his remuneration, and a notice period of 6 months. The day before he accepted the role, he received an email from George Sanders, the CEO of HHMB, that said, "Dear Ivan, great to catch up. Happy with your REM at 240 plus super and attached commission schedule. The long-term incentive is set out in Schedule 2. Notice is 6 months. All okay? You understand there's an oral agreement, and here is a notification of what George wants him to agree with. Cheers, George." So what does Ivan say? Ivan comes back and said, "Done deal, George. See you on Monday, Ivan." All right. They executed the contract indeed on the Wednesday after he had started. The deed contained restraints for all clients he had worked with or his staff in Victoria over the last 12 months and applied to similar broking businesses. 8 months later, Ivan realised he had made a big mistake and resigned. He is placed on gardening leave. That is, he's sent home and he's told he's not allowed to do any other work for anybody else. He's still an employee and can be called upon to do work as and when it is required. Whilst on gardening leave, he arranged a new job with Fast Mortgages Proprietary Limited as their national sales manager and introduced some clients surreptitiously before his 6 months leave expired. Okay, the first question is, was the contract enforceable? Now, I want you to have a think about this. So there is a lot of discussions, okay? There's an email and they agree on something at the time of that email. Do you think that's a contract?
Yes.
Yes, it is. That's exactly right. I'm glad I nodded my head correctly. So if I say to you, honey, we can go out on Friday night and we can go and have dinner, and you come back and say, "Oh, what time is that, Dad?" And I go, "Look, it's 6 o'clock, but you can only go if you're well behaved." And you go, "I promise I'll be well behaved." And I give you a contract afterwards which lists 20 things that you have to do. We've already agreed to the agreement by the exchange of email at the beginning and our discussions. So the answer is, was the written contract enforceable? The law is, if a written contract contains clauses which are inconsistent with the agreement that was previously reached verbally or in writing, it will not be enforceable. And the second rule is, past consideration does not perfect a contract. That is, I offered Moon to go out for dinner on the basis that she was well behaved, her consideration. The moment she accepts that, a contract is done. There's no further consideration if I give her a document and say, "Sign this document." So on two bases, the written contract was not enforceable. Okay, now that's very, very important. Just going back to the oral one and the emails, that contract is enforceable, but there's a lot missing. So the court will imply terms which are reasonable into it, but it won't imply specific obligations which arose in the contract. Which throws you to the bigger question of, was the deed enforceable? Now, I don't reckon you're going to understand this, okay, but I'm going to say it slowly. In a contract, there must be consideration. You must do something for me and I do something for you, okay?
Like trading.
Yeah, it's like trading. It's exactly what it's like. But in a deed, the very nature of the deed means you don't have to have consideration. You don't have to trade. It is an obligation you give under seal that says, "I would do it. I know there's no consideration." Okay? So on its face, the deed as a document could be enforceable. The problem is the deed is incorporated into reference in a contract, and for which there was no agreement to enter in at the time the emails were entered in. So it's highly likely the deed is not enforceable, although it's arguable. Okay? To the extent the deed could be enforceable, it's far too broad, isn't it? It involves clients he had no control of. It had no limitation on geography. So, and the other part is the description of what it dealt with was too broad to be enforceable, because you can only enforce a deed that is reasonable to the individual circumstance of the person giving the commitments. Does that make sense?
Yeah.
So on the first two, Ivan's out of problems. He has no difficulty. But the third question is a tough question. Was there any action that HHMB could bring against Fast Mortgages and Ivan? And if so, what is? Now, here's the rub. He was sent home, and during that time, he was an employee of HHMB. Is he allowed to try and take advantage and use the information of that business to another business while he's still employed with HHMB?
I don't think so.
No, he's not. You're back on the winning streak again. He is not allowed to do that. That breaches duties under the Corporations Act, 181 through to 185. It breaches his fiduciary duties, common law and equity, and it's very easy to prove. Okay? So not only that, Fast Mortgages is in trouble because it procured, assisted, or helped him in breaching his contractual obligations and is therefore liable as well. So what could HHMB do? Well, they could get an injunction, but damage had already been done. But they could get an injunction to stop further breach, and it would be easy and successful to achieve. Okay, so they could do that. Remember, after a notice period is complete, it's much harder. But they could also bring a thing called account of profits, which is a particular action which captures the gross profit that is lost as a result of the breach, not the net profit, the gross profit. So you can see what a powerful remedy it is. Now you can also, because of the repudiatory nature, get future losses. You're starting to see that this is a very, very substantial claim, and where it looked like the strength was in the contract and the deed and they're not enforceable, actually the breaches here were much more real and much more dangerous for both Ivan and Fast Mortgages. So look, I think this is a fascinating case. What do you reckon?
That's really fascinating.
You're really fascinated by it. I tell you what, you give Kim and Nina a run for the money. You've got more right than they ever get right. Sorry, Nina and Kim. I shouldn't say that. You got any other questions there, or is that all the questions for today, Soph? I think that's all the questions for today. So can you ask people to give them a thumbs up?
Thumb up.
Say thank you for watching.
Thank you for watching, everybody.
See you later, guys. Bye-bye.
Have fun.